I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started today, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says that I've got to say it, so I've said it. Nothing is ever going to prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. How much are you entitled to when you file a claim for your long-term disability benefits? If you're totally disabled, your benefits are going to be based on a fixed amount that you purchased and perhaps maybe even bought some additional increases. You may have started with $5,000 per month in coverage, but you've exercised options that let you buy it up and now have $6,000 worth of coverage. That's pretty easy. But what if you've got a residual disability benefit claim? Now, residual benefits are based on your covered before monthly income. Your policy may say, look, to determine what your before monthly income is going to be, we're going to look at your income tax returns. And we're going to base this on the highest 3 out of 5 year earnings, or the highest 1 out of 2 year earnings, or the 12 months before you became disabled. Some policies will say that bonuses, commissions, or other designated income isn't included in the BME. And that can be a problem because what you thought you bought in terms of coverage may be something completely different. So if you're self-employed, like a doctor, a dentist, or a lawyer, some of these policies are going to say, look, calculate your benefits. We want to see your monthly P&Ls, your billing documentation, or other income before we can determine not only your before monthly income, but your monthly income. Now, why is all of this important? Well, because the calculation of your before monthly income is the starting point to calculating your benefits. And that calculation is going to be done monthly. So today's episode is all about the wonderful world of before monthly earnings calculations. And the three things that I'm going to be talking about are how pre-disability earning language can impact the amount of your disability benefits, what the court says. In other words, the court says just because a carrier or an employer thinks their calculations of pre-disability income earnings is correct doesn't make it so, and why discretion can make all the difference in your disability insurance claim benefit calculations. So let's take a break for a moment before we get into today's episode.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Why discretion makes all the difference in your disability insurance claim. Now, I know you bought a disability insurance policy to provide you with peace of mind if you became disabled and unable to work. You probably thought that if you became disabled, that the insurance company was going to send you a check. And if it was that easy, I wouldn't have a job. I mean, I know that your doctor said that you were disabled and unable to work, but that doesn't mean that the disability carrier is automatically going to pay you your benefits. One of the most important terms in your disability insurance policy is something called a discretionary clause, and it's normally buried in the back of that policy. That policy term, the discretionary clause, says that the disability carrier has the discretion to interpret the terms of your disability policy and to determine whether or not you're entitled to your benefits, regardless of what you say or what your doctor has to say. How ultimately a court reviews a disability carrier denial is called the standard of review. Now, generally, there are two possible standards of review. There's a discretionary standard of review, which quite frankly means that it's an uphill battle in court if your claim is denied, because a discretionary clause is a policy language that allow them, the disability carrier, to steal your benefits. There are some states like California or Illinois that ban discretionary clauses just because of that reason. In that case, the judge can only overturn a claim if the carrier's conduct is arbitrary and capricious. Now, the alternative and more policyholder plan participant friendly is the de novo standard of review. That allows the judge to independently review the claim and make their own independent judgment. The discretionary clause, in my view, is a golden handcuff. It basically says to the judge that you can disagree with this decision, but because we have the discretion to make the decision, you can only overturn that if there's been an abuse of discretion. I mean, you can disagree with it, but you can see that there are legitimate reasons, in our view, that we had to deny the claim. And of course, bias wasn't a factor in our decision. So, judge, you're bound by our denial. And unfortunately, that's exactly what happens in a discretionary review case. If I had a choice, I would always want the de novo standard of review, because I would rather take the chance and have the judge review the material and make an independent decision. So we've been talking about the concept of pre-disability earnings in some of our earlier segments. Let's talk about how the standard of review will work in the real life in a before monthly income case. And I'm going to tell you the story of Mayer versus Ringler Associates, which is a case involving the Second Circuit. Mayer was employed at Ringler Associates, and Ringler Associates offers annuity plans to help cases get settled, be they workers' comp case settled, personal injury cases settled, or any other kind of disability litigation. It's a big company and big business. Now, Ringler Associates offered a disability insurance plan to its employees. It was administered by Hartford. And Hartford approved Mayer's disability claim, but they fought about how much his pre-disability earnings were. And of course, that ultimately would impact how much he got paid in disability benefits. In this case, the policy had a discretionary clause. And the first issue the court had to decide was whether or not the discretionary clause was applicable. This gets as complicated as the before monthly income calculations. The plan was delivered in California that prohibited discretionary clauses, but Mayer lived in New York. And guess what? New York allows discretionary clauses. Mayer argued that since the plan was issued in California, that the discretionary clause was inapplicable and the judge could use the de novo standard of review. Well, Hartford, of course, argued that the discretionary provision was applicable. And since he lived in New York, they got to apply the discretionary clause. The court rejected Mayer's argument because they said, look, if one plan participant was a resident of California, then the discretionary clause would have to be applicable to all plan participants. And the court held that that would be a logistical nightmare for the disability carrier. And as a result, the standard of review that the court applied had to be determined based on the policyholder's residency. And in this particular case, the court relied on Hartford's discretion in calculating the amounts of the pre-disability earnings. So the standard of review can make all the difference. Now, I think that there should be an argument that may be made in a case like this, that since it's a policy contract interpretation, that the court should apply a legal doctrine called contra proferentum, which means that the terms of the policy should be construed against the author of the disability policy if there's any confusion or conflict or lack of clarity about what the terms of the policy mean. So when I'm involved in a dispute, particularly when it's a plan language or policy language interpretation clause, I argue that even if there is a discretionary standard of review, that the court should be applying the doctrine of contra proferentum and interpreting the terms of the policy in favor of my client. But you can see two of the major factors here are going to be where does the policyholder live, what state law is applicable, and as a result, whether or not there is discretionary review or de novo review. And I quite frankly think that's important that you understand in your disability insurance claim prior to you filing a claim, but certainly when we get into the area where the claim is being delayed, denied, or terminated. Because ultimately, when we have to file an appeal, it's going to be the standard of review that will govern how we file the appeal, what we argue, and how the court views not only the facts of the case, but applies the correct legal standard. If you need help with your disability insurance claim involving before monthly income calculations, you really do owe it to yourself to consult with an experienced ERISA disability attorney. We're dealing with contract terms, interpretation, employment agreements, math, and trying to apply correctly based on the applicable case law how those calculations go. And it's not, quite frankly, for the faint of heart. If you've enjoyed this week's episode, please consider liking our page, leaving a review, or sharing it with your friends or family. Remember, this podcast comes out weekly, so tune in next week for another insightful episode of Winning Isn't Easy.